Thank you, Mr. Gupta, members on the panel, senior advocates, other advocate friends, members of BAI. Thank you to the BAI for inviting me for this conference and for this session. Today, as we speak on the Bharatiya Sakshya Adhiniyam, I have made a small PPT really to enable myself to understand it better in a way, and hopefully see what it's about. And as we this was enacted recently in 23 and comes into force from July 1st, 2024. And as many of the other speakers have discussed even in the previous session, it's it's quite similar to the Indian Evidence Act, which it seeks to replace with very, very minimal changes. And how do we look at those new aspects that have come into force? So I thought I'll just give a brief overview. The Act is, most of the provisions are very similar. There's a lot of renumbering and restructuring of the sections. Like the other criminal laws, there's been an effort made to remove certain colonial references, wherever the sections refer to the British Parliament, other colonial terms, those are, there's a point made to remove those references. And then I think the only aspects where it has made certain changes or added a few things are on the provision of electronic records and digital records. I'll go into that a little bit. It expands on what is secondary evidence, and then it adds a few more other minor provisions. So the biggest addition to the Act has been on electronic records. So it first says that any document includes electronic or digital records, and then it gives an illustration that these are emails, server logs, documents, all of that from websites, and all other kind of, an expansion is made. To some extent, this was anyway covered in with the amendments made in the Evidence Act as it stands today, because electronic records have also been included, but this kind of makes it a little more explicit. And then it looks at it says that electronic records will be seen as primary evidence. So it says very specifically that electronic and digital records will be seen as primary evidence. It clarifies it that if documents are created and stored in multiple files, then each of those files are primary documents themselves. It also states that if they are equal to paper records, so an electronic record will be seen in the same way as a paper record as a primary document. I mean, though these clarifications are made, a lot of these provisions were already included in the Evidence Act with the recent amendments to include electronic records. I think one or two places where it makes a little more, clarificatory changes is that where it says that it is not just those produced by a computer, but also any communication device, because now we see that a lot more documents are produced by phones and other means. So that has been added. Importantly, the entire issue of the Section 65B certificate is retained, though it does not, it gives it in the schedule. There are two forms given. So those same provisions are there. The only difference I would say is that currently in trials, when electronic records are sought to be produced, though the Evidence Act at the moment talks about a certificate under 65B, often affidavits are also filed. Here there is a template given in the schedule, and not only does it say that the party can give it, an expert can also give it. And if an expert gives this certificate, then they also have, there are some additional requirements that you have to give the hash value, etc. Now this, are we going to move to a situation where instead of the parties giving the 65B equivalent certificate, are you going to have more experts coming on record to give these certificates? Does the Act envisage that? I mean, that's something for us to discuss. The second issue is that there's been some expansion on what is secondary evidence. So secondary evidence has been expanded slightly to say that secondary evidence would include oral admissions, written admissions, and evidence of experts, so expert evidence. So if there's now this has been included as secondary evidence, and importantly, it expands and puts a provision that if for any document, the document is not seen as a genuine document, or there is some difficulty in accepting the original document, then you can provide a secondary evidence for it. But what kind of secondary evidence if there's a dispute to a document? There's no mention of that. So how would such a document by secondary evidence be proved? So, I mean, so while it expands it, there are some areas which leaves it a bit unexplained. And then there are certain other minor inclusions, I would say. For confessions, there's another, in addition to confessions obtained under threat, there is coercion included. For judicial notice provisions, these are again very, very minor. There was many academics have even made tabular columns comparing the Indian Evidence Act and the new code. And so for judicial notice, what things the court can take judicial notice of, even international treaties and international agreements have been included. In attorney-client privilege, for example, they've included the scope to include even employees or staff and clerks of attorneys or advocates. Now, this is, while this may be a good thing, I think in our trial and practice, the entire issue of attorney-client privilege itself we don't use too much, and that is not brought up in trials in a very strict way. But anyway, that has been expanded, and yes, so exclusion of production of any privileged communication between ministers and the President of India, that has been included if we do a strict comparison. So while we look at these changes, I think there are still some issues which remain. These are issues with the Evidence Act. But when there have been steps taken to expand its scope to some extent, for example, in expanding the scope of digital and electronic records, this was an opportunity where it could have been a way to address tampering of records. And that has not been done. Many issues were raised, both Aditya raised it, on the genuineness of the document, on the admissibility of the document. Even in the previous session, what do we do with tampering of documents and fake documents? And today we see that with electronic records, it's extremely easy to concoct electronic records. Today in many trials, especially, we routinely, emails of course are produced, but we routinely see call logs, WhatsApp message logs. How do you ensure that these printouts and logs are in fact genuine? You give a 65B certificate or an affidavit, or even the certificate which is now required. You may even give a pen drive, but who is going to authenticate and verify that what is given is actually untampered by a party or by anybody producing it? What is the source of it? Is the phone going to be sent for forensic examination to first examine whether it's tampered or not? Photographs are produced, images are produced. Even without going to trial, we see online, the level of tampering that is there on social media. There are deep fakes which are at a very, very high level. So then what are we talking about? Ordinary electronic records produced in court, in trial, civil or criminal. Voice messages, videos, or call logs? How do we ensure that these electronic records, we are expanding the scope for electronic records we produce as primary documents, but how do we ensure that these are in fact genuine documents and untampered with? So that has not been addressed, and this leaves open a large area of concern. And then the certificates, and also by the other issue is by experts. It specifically refers to expert evidence. Are we, I think in our civil and criminal trials, are our courts and lawyers, is the legal system going to be equipped to deal with a lot more expert evidence? This is not something I think that routinely our courts and lawyers take up. And so when we expand the scope, are we going to be able, is the system going to be able to take this up and address it and manage it, is something what we have to see. So yes, so overall I think the Indian Evidence Act remains more or less the way it is, with a little bit of minor restructuring and renumbering really. But I think core issues remain. This was an opportunity for an amendment of many other provisions. But unfortunately, those amendments have not been done, and I think we're left with many of these challenges that we have been facing, especially on electronic records. And so we have to, I think, really discuss how we take this forward and how our courts are going to manage these risks. Thank you.
Thank you, Jayna.